Severance agreements are not just about severance pay. In fact, there's a lot you're giving up, including things that might impact your next job. Hey everyone, it's Acacia, the CEO legal coach. Today we are here talking about severance agreements. And when you're laid off, believe it or not, your employer is likely going to take a lot of action in that agreement to limit where, how fast, what you can do in your next job. Right? They're laying you off, and yet they're saying, by the way, you also can't just go get any new job. So that's what we're going to talk about today. How does this impact things? What does that mean for you? And I always do, if you're not familiar with me or how the Aligned Business Series goes, which is when I go live 3 times a week, that I always have a live Q&A. So please add your comments, please add your questions into the chat. We will get to them at the end once we get through all of the core content, okay? And I always try to keep these under 30 minutes, but with questions, sometimes we go long. Okay, so let's dive in for a second. What does it even mean when we have a severance agreement, and how does it impact your job? So the severance agreement that you have in front of you, your employer is offering you severance, which is really nice and, let's be honest, really shiny and distracting when you're losing your paycheck. When you've just been told you're laid off, like, money suddenly becomes a different type of worry. Maybe you were worried about it before, maybe you weren't, but now you definitely are thinking about it in a way you hadn't been. And you want to get the next paycheck lined up or start that business. Use this to get yourself onto your future. But as we're going to see here, I've got about 5 different areas where your severance agreement might limit your next job. And then we're going to go over 2 more where it's going to limit the pay you get. Believe it or not, that severance pay may not all be yours. And it might even come down to whether you get employed. It's horrible, right? But then also something else that you can ask for to help you in your new job. All right, so a lot to get through. First and foremost, what is the very first section on a severance agreement that is going to be your number one limiter in getting another job? It's called a non-compete. A non-compete clause stops you from working for a competitor, people in your industry. It could be very, very broad. It could be just, hey, you can't work anywhere in 200 miles. And it's like, anywhere? Anywhere. Like, what? Versus sometimes it's just you can't work for our competitors, or you can't work with our clients or vendors or competitors. So how your non-compete is worded is really, really important, because you want to know what that scope is. You don't want to go apply for a job and then be told you can't work there. You have a contractual agreement not to. It sucks. Or worse, they sue you for it, but more likely they're going to come and tell you can't do that. And you're like, but wait, I needed a job. It's really important to understand 99% of severance agreements are going to have some type of non-compete. It's also very likely that you've already signed some type of non-compete back when you signed your offer letter. Your offer letter is when your current employer, the one that's letting you go, when they gave you the job you have. When they gave you this job, said, hey, here's your salary, here's how things are going to go. Some of those other words on the page were very likely non-compete back then as well. So know that there are likely layers to it, and this is how that's going to go. So the non-compete limits where and how quickly you can get a job. And I have seen non-competes. They're usually 6 months to 2 years. 6 months to 2 years. And sometimes they're limited to just you can't start the job. Others are you can't apply. Imagine not being able to apply for a job in your industry for 2 years. What are you supposed to do? The FTC tried to ban non-competes across the board last year, and that got overturned in court, which is a real bummer, because I do think there's a certain level of employee where it would be beneficial to, if they're laying you off, just go get it, let these people get a job. But anyways, it got overturned. So now non-competes are state by state. Some states, almost anything on that paper, your employer is able to do. Like I said, they could prevent you from getting any job in 200 miles for 2 years. What are you supposed to do? Relocate? So being mindful of what's on the paper, where in other states, it must be limited to direct competitors or very limited in time, things like that align more to your job, right? If you have a job that had a lot of sensitive information, the business plans for the next 2 years, well, that would have a little bit more limitation on when and where you can go versus somebody who was just like, I was just selling like their basic product. Like, I don't know what's happening with the company at the executive level. So these types of things, okay? Now, one thing I like to always recommend is that when you have a non-compete, get it clarified the way you need it clarified. Get it clarified the way you need it clarified. Just the way they put it on the paper does not mean you have to accept it that way. By the way, you never have to sign a severance agreement, completely optional to sign it. But if you don't sign it, you don't get the money. But one of the things I always recommend in this non-compete is get it articulated, not just in what is and isn't allowed, but the actual companies you're not allowed to go to. Because hear me out on this. If you can get them to say, I don't want you to go to these 5 competitors, now you know they can't come back later and be like, oh, so-and-so is now a competitor. You're not allowed to go to them. You'd be like, no, you said these 5. I didn't go to these 5. Another thing is what types of roles or situations. I used to work with Fortune 500s. Fortune 500s have like 5 different divisions. I only worked in one division. I have no idea what the hell goes on in the other 4. And I'm definitely not going to be working to undermine them because I don't know what's going on in them. So if I go to a competitor of a Fortune 500, well, that could be almost anybody in a number of areas. So I would get it limited to, you can't go work in this specific division for these competitors. See how that's different? And then saying you can't go to any, because there are some industries where it's just large businesses that it's been around, companies have acquired and merged and things like that over the years. And so you're limited to these specific, like what you can and cannot do. So when they just list the whole Fortune 500, well, that's broader than what is necessary. So get these types of clarifications. And then how it helps you is, let's say 3 months down the line, somebody that wasn't a competitor before, but is now, suddenly is the place you can go work at. Suddenly is a place you can go work at. Or you can work at their competitors, but in other divisions, other types of rules. And then when your non-compete is up, then you can move directly to compete with them. See how this helps you open more doors that would be closed if you have a general non-compete on your agreement. But know that a severance agreement 99% of the time will have a non-compete in it. It's probably enforcing or expanding the non-compete you signed on your offer agreement. So the next way, I know there's going to be some questions about that. Go ahead and get those questions into the chat, guys. Don't worry, I will get to your questions. I promise. Okay. The next one where things can start to affect you is a non-disclosure. Non-disclosure agreement, sometimes called an NDA, might just be in there as a non-disclosure paragraph. Why this matters for your next job is one of the biggest things that I see happen is that when you have a non-disclosure on the paper, it says that you promise to keep the company's information secret. You promise not to use it. You promise not to share it, which means sometimes the knowledge and experience you've acquired over your career technically belongs to somebody else. But you're going to go on in your career and do what you do best. Share what you do best. Share what you know, your experience. So sometimes sharing that or using that is in violation. And when I had a family member, this happened to a family member, so this is a real personal story, is he had worked for this company for, I don't remember how long, like a decade or something. And he ended up over that time creating a customized software program for them. So as the company grew and changed, he was the one in the back end building and creating this thing. So when they let him go, he's like, I'm going to go create my own company, my own consulting firm, and use, I already know how to build this product. I don't need their product. They can have theirs, but I know the back end code and I can create my own version and customize this for others. Nope. He was not allowed to use that information because he worked for an employer, gave it to the employer, and because it was created within his employment, that intellectual property belonged to his employer, even though he's the one who created it from scratch. He's the one who was the brains behind the whole thing. They ended up creating a whole department around him and its knowledge, and he didn't get to take any of it with him in his future because he had signed away. When usually on an offer letter, you sign saying, hey, yeah, anything that I create and do in this job belongs to my employer. This happened to another family member. His name was on a lot of patents. But those patents were created under his employment umbrella. And so his employer's name is also on those patents. And because they were created under the employment umbrella, he can't go use those own patents on his own stuff, even though his name's on them in the USPTO. They happened under his employment. They belong to the employer. So non-disclosure can go beyond just sharing insider info type of a thing. It comes down to the intellectual property and what your role is, what you created while you were there. You can't take that with you to a new employer. You can't take it with you to your new company unless you get permission to. Okay, so this is why we want to look at the non-disclosure on your severance agreement, because that type of expertise, knowledge, and experience might be capped or limited when you go to whatever you do next. So you want to check out the non-disclosure, like I said, confidentiality there. The next one that happens on a severance agreement is the non-solicitation, which, by the way, guys, I realize I didn't put this up. I have a whole program where I put everything I know about severance agreements into different modules, pay modules, insurance modules. This, your next role, is a whole module where it's got the videos, it's got checklists, it's got guides, all that in there. So if you need more details about any of this, know that I have that there, okay? That is available to you. So don't feel like you have to rush taking notes, but there's a whole program where I really, really deep dive into this. So, okay, so we were talking about non-solicitation here for a sec. Non-solicitation. It's a rule that stops you from recruiting the people, right? We just talked about you can't take certain ideas and IP and things like that. Well, now you can't take the relationships. Now, some non-solicitation clauses will be like, okay, well, you can't take our clients with you. Well, that kind of makes sense. It's not fair that because you got let go, you get to take the company's clients with you. But sometimes it also says you can't use your relationships with our clients or with our vendors or with any of our staff to get your next job. You can't use your relationships with any of them to build a new company. You can't use any of that. You definitely can't poach them from us. You can't encourage them to leave us. So that's non-solicitation. It's about protecting the employer's relationships and the ones that you gained access to and got to use because you were employed by them, because now you're not employed by them. Okay, so that's non-solicitation. Rehirability. This is a big one. This is a big one. Oftentimes when we leave a company, when we're being laid off, it might just be because there's a cash flow shortage or something's going on in the economy or the industry. And they're like, yeah, we want to hire you back. 8 out of 10 severance agreements will not allow you to be hired back. It's called rehirability, but that's probably not the word it's under. It's usually just a random sentence, and it could be anywhere on the document, okay? And what it is a sentence or clause that says whether or not you can work for that company again. And like I said, 8 out of 10 times the answer will be no. And you have contractually agreed to this. And it's going to be on file with HR. So you're not allowed to ever come back to this company in any form or fashion. Not even 20 years down the road in a whole different division. You have contractually said, I will never work for you again. But they can sometimes go further. I recently saw one where it wasn't just you can't work for us. You can't work for our partners or our affiliates ever. We don't even know what affiliates is right now, let alone what it will be in 20 years. What do they end up taking over the entire industry? Think of some of the big like Fortune 100 companies. How many smaller brands and smaller pieces do they have to them? You might be saying, I will never work for you again. I will never apply to you again. And if I do, I'm in breach of contract. They could fire you the second it happens or they realize it. That sucks. So it's really important. Like I said, 9 out of 10 severance agreements will have this in there. 8 out of 10 will say you're not allowed to return them. So if that is something that you're anticipating, if that is a conversation you've had with HR, your boss, your team members, make sure that clause, that statement is clarified or removed so you're not prohibited from coming back, okay? That's really important if you have any intent of being hired back on in the near future. The next clause, I know we're still going. We're on this is the last clause, and then we're gonna go over 2 things about money and ways that you can get support in your severance agreement. Yes. So this one is called non-disparagement. This one, again, that word is called a non-disparagement, but you're never gonna see that phrase on the document. I don't know why we give things names and then never use them. But what it is somewhere in your document, you're going to find a clause that says whether or not you or the other side can say anything bad about each other. 9 out of 10 times, it's going to prohibit you from saying anything about them, but it's not going to prohibit them from saying anything about you. So it's an area that we can negotiate. Why this matters. You might need them as a reference someday, right? Hey, your next job might be like, we want to check your last 3 employers, write them down. And then what are they going to say? When your future employer calls them and says, I want to verify their employment with you, what is going to be said about you? Yeah, we let them go. Their last day was September 15th. That doesn't sound too pretty, even though it is what happened. So we want to clarify what they can say about you, and they're definitely going to want to clarify what you can say about them, right? You don't get to go to the press and be like, they were shitty, they did this, they did that. They don't want their reputation ruined, which is why you're going to see it in the majority of severance clauses, agreements. But if you see it, I want you to go back and make sure it's mutual. I want you to make sure it's mutual, and I want to make sure you get the references you need out of these people, because it is not your fault you're being laid off, and you should not be punished in the future moving forward because of what they have decided to do. And so that's really important to make sure that is mutual. It's a mutual thing. So, all right, we've gone through the main clauses. Don't forget to get your questions into the chat, because I'm about to get to all of those, okay? And let me see. Now we want to talk about the two things that really matter when it comes to, first is the money, okay? In exchange for you giving up usually a lot of rights, far more than we've even talked about. We've already talked about, 5-6 ways that severance agreement can limit you getting your next job. And that's not all they're asking you to waive. This is just one of 4 areas. But what they're going to do is give you money for that, right? That's what your severance payment is they're paying you to give up your rights. You think they're paying you as a gift or for your service. No. 10, 20 years ago, yeah, that's what severance payment was. It was a thank you. It says, oh, sorry, we're letting you go. Now it's a business exchange. And so what ends up happening is that once you have found your next job, usually you will find a clause in your severance agreement that says you now have to tell the people who just laid you off. And if there's any severance payments left coming to you, any benefits, they're now extinguished. So let's say you get 2 months of severance, but you find a job in a month, you don't get that extra month. And you have contractually said you're going to do this. So you're in breach of contract if you don't. So it's really important to know if your severance agreement has anything that is about whether or not you're going to have to tell them and if it cuts off your payments. Whether or not you have to tell them and if it cuts off your payments. Okay. So one way to get around the payments, we've talked about some other things about getting around your non-competes, is get more money up front. Get more money up front. Get it in a lump sum. Hey, instead of it going 2 months, just give me a 2-month lump sum up front. That way, when you start your job on week 2, you're not going to lose anything. You still get the value. So understanding how the value of the money is versus the dates of when you start your next job. I also, this is something I didn't mention. When let's say you have a non-compete that's 6 months. Let's say you're not allowed to apply for jobs in your area for 6 months, but your severance package is for 2 months. Well, what's supposed to happen those other 4 months? That's not a fair value exchange. So remember, you are giving up something in exchange for that money. Let's make sure you get money worth what you're giving up. So either you want to give up less or you want to get more money, right? That's that. There is not a law that says how much money you can get other than the laws that say, well, I'm not aware of a law. Let's put it that way. I am not aware of a federal law, and there's not a state law where I am licensed. So check. This is one thing. Everything is state by state when it comes to severance agreements. Everything is state by state. So double check. But off the top of my head right now, where I'm licensed and in my experience, I am not aware of a cap in the amount of money you can get for your severance other than the one regarding pension plans. What makes a severance payment different than a pension plan is that pension plans are intended to be retirement benefits, but is the amount. So your severance is not allowed to go more than double what you made last year. Then it becomes a pension, which is a different situation, which gets taxed differently, everything. So that's the only one I know of, right? There might be others, but that's the only one I know of. So generally speaking, though, back to what we were saying, though, if they're going to pay you for 2 months, but you're not allowed to apply for 6 months, well, you're going to need at least 7 or 8 months, because by the time you can apply, you still need time to get the jobs. So making sure there's that fair value exchange in every single element that you're giving up and what you're getting. And then the other thing that is negotiable that most people don't realize, and it all comes down to who you are, what you might need, is sometimes, especially for bigger companies, they'll pay a recruiter, or they'll pay to get resume services, or they'll pay to help you set you up for success to get the next job, okay? Because they would end up having to do their unemployment insurance and all these other things. So it's something you can negotiate in sometimes is, hey, you're the one laying me off. I want help getting my next job. And if I have to hire a recruiter because of the type of industry we're in, I want you to pay for that. So just know that that is something that you can do. That is something that you can negotiate in. All right, are we ready? I see the questions. Oh my gosh, this is a long list of questions. Okay, we've got we have 9 minutes to get through all these questions. Oh my gosh. Okay. How do I know if I even have a non-compete? Okay, 99.99% of the time, it's going to be in your severance agreement and or your offer letter. Right? You may have already signed one. So first off, go look at your offer letter. If you don't have your offer letter, ask HR for it because you want to be fully aware of it. But they're almost always going to put some limitation on where you can go and how fast you can go there. Almost always. I've never seen a severance agreement that hasn't had one, but I don't want to say 100% of them just in case there's that one out there that didn't have it because it was written by somebody who didn't know what they were doing or ChatGPT did it or something. But you're almost always going to have one. So the key is it may not have those words. It may not have the words non-compete. It may just simply start to say employee promises not to go to any of the following places for the next 6 months, or you're not going to apply. Look for words like apply, hire, competitor, competitors, vendor, suppliers, anything that they might look to generally. It's usually in general words, and they use general words because they can interpret them how they want. It's another reason why you definitely want specifics in your severance agreements, why I recommend having the list. If you're really uncertain, you can ask, but the hesitation I have about having you ask them is, one, asking them doesn't mean it's not in the agreement or vice versa. What they clarified doesn't, if your agreement says you can't go to anybody for 6 months, but then what they say is, well, what we really mean is, well, you can't go to our competitors for 6 months. If that email that you got from them isn't explicitly listed in your agreement, it doesn't apply. It doesn't apply. So it's a little bit dangerous. And also, what if you were the 1% that didn't have one in there and now you open the door? So I would prefer you search for the types of words, skim it, scan it. It's very likely to be in there. Okay. If my non-compete is too broad, is it enforceable? Oh, this is a great question. Okay. So I think I mentioned that the FTC tried to ban non-competes in general last year. Try to waive them across the board except for certain types of positions or roles because they can be so predatory and overly inclusive. Like I said, they can prevent you from getting any job anywhere in 200 miles for 2 years. What? But it is important to know that non-compete laws vary state to state. Every single state has different laws. Some states let almost anything go by. Like the one I just said, 200 miles. But other states are very specific. Like it must be related to your specific job, must be the employer has to demonstrate that it would harm them. The time must be limited. The geographical situation must be limited and things like that. I think California, I'm not licensed in California, but my understanding is they're pretty narrow in what is even allowed. But here's the thing. It is better to negotiate the non-compete than to sign an illegal one. Why? Because you don't know yet, unless you go to a lawyer, that it is in fact illegal. And I have seen this where people are like, oh, I can tell it's illegal, so I just went and violated it. Well, you're still in violation of a contract. You're still breaching a contract. And so now you still have to go through all of that. Your employer can still come sue you, enforce it, cease and desist, all of those things. But also, they're going to tell your new employer. And your new employer is going to want nothing to do with that. So they might just drop you just to avoid being involved in the lawsuit, whether or not the non-compete was legal. The new employer may not hang around the year or two to get through litigation to find out. So it's best never to sign one that you think is illegal to begin with. If you have any concerns about that, please find an employment lawyer in your state. I cannot enforce that enough. So much information online is general. So I don't want you following, Utah, a blog out of Utah if you're in Florida, right? I want you to make sure that you know that those are very, very different. What's the difference between a non-compete and a non-solicit? Sure. Yeah, non-compete. You can't go to competitors. You can't do anything that's going to compete with their vendor relationships, with their supplier relationships, with their client relationships, that competes with their products. So the compete element, right? You can't build a business that does things like that. Now, compete is generally vaguely interpreted. So like I said, my family member, that the software, he's not competing with them. That company doesn't even sell software. That's not what they did. But he had created software within his employment there. And so they were like, you cannot have your company that does this. Where a non-solicit is from solicitation, it's about the relationships. So it's one thing to not compete with them on paper or product or services. It's another to utilize the relationships. You can't use the relationships with our vendors. You can't use the relationships with our clients. You can't use the relationships that you have internally. So solicitation is about the people and the relationships. Not compete is about the product, services, and what's going on, like what brings in the money. So two totally different things there. And that's kind of the way to remember them. Compete is about competing with them, and solicit is about the relationships. If I remember information in my head, does an NDA still apply? Majority of the time, yes. You don't have to physically steal the papers. You don't have to sneak them in your briefcase out the door. You don't have to download those files onto your hard drive or into the cloud. In fact, please never do any of that. But that's not what it means to steal. Because ideas themselves, the processes, hey, back at so-and-so company, instead of doing this, this, and this, they did it this way. That's insider info that you've got because you work there. That might be a trade secret you just shared. Because if that process impacts their money, impacts how they do business, impacts their competitive advantage, it's likely a trade secret, right? And so that type of stuff right there can be a violation of a non-disclosure agreement. Yeah, many violations of non-disclosure agreements are not intentional. Most people are trying to be good people. You're probably a very good person. I trust that you are. So it doesn't end up being intentional stealing. Intent is not part of a non-disclosure. It's simply saying you're not going to use that information or share that information. No bearing on whether you intended to or not. Complete accident still counts. Yeah. Why would a company ban me from being rehired? Great question. A few reasons, but the number one reason is retaliation. People can hold a grudge for a really long time. So let's say you get hired back 2 years later, you go inside there and you ruin things from the inside. You release stuff to WikiLeaks. And we've seen these types of things, right? That retaliation from the inside, that harm, that's usually why. They also don't want you to have an idea of a lawsuit, come back in, get the information for the lawsuit. Those types of things. So whenever they put something into your severance agreement that you're waiving or giving up, it's to protect them. There's something that's protecting them. Yeah, that's the retaliation is the number one reason, I think. Does the no rehire apply to subsidiaries too? 50-50. 50-50. The rehire ability thing, like, can they hire you back? Check. I have seen simply, you promise not to apply or work for this company again. But then, like I said, I've seen ones where it's like, you can't go to our subsidiaries or affiliates, anything in the family. And what's difficult about these is what's in the affiliates, the subsidiaries, the family now might be different in 5, 10, 20 years. So that type of information is good to know. So just look at the words. It's usually a very simple sentence. It could just be a few words in that sentence, but it might be packed into a paragraph somewhere else on the paper. But double check what it includes, because they are all different. Can I post on LinkedIn that I was part of layoffs? Look at the documents. Look on the documents. If you're saying if they haven't made layoffs public, you're disclosing behind the scenes information. If you're seeing anything about bad, like they're a bad company, they do this. Yeah, so it can kind of come to the idea of the general information that they've released, right? We know that Oracle, ConocoPhillips, I think some of the casinos here in Vegas, some other things, they announced their layoffs. So saying that you're part of that, you're not violating anything. But if you say something bad in that, something negative about the employer, ConocoPhillips, I don't want to use a word, a name, company A, B, and C laid off their best employees. I cannot believe they did. Now you're letting that emotional fuse into it. That's where we start to get into that non-disparagement, harassing, saying the wrong things type of thing, okay? So be mindful of that, because what you post on that internet can be seen, can be picked up in the media, anything like that goes back to them. But if you haven't signed, away that right. If you don't sign your severance agreement, unless it's in your offer letter or something else that is there, you don't have to waive the right. But if you want that right, I would not sign your severance agreement. Yeah, okay, we're already at time, but I'm gonna hit these last two questions. I think there were two more that I saw. Let me see. Are resume and career coaching services really valuable and available? Yes. Yeah, like I said, sometimes recruiters, so sometimes new employers don't like to work with recruiters because then they have to pay the recruiter a fee. Well, let's see if your current employer will cover the fee. And then that way all a recruiter is doing is using their existing relationships. Because that's the thing about a good recruiter. If they are industry specific or geographically specific, I've had some in my career, they know everybody. They know everything about everybody already. And so they know if a company is looking without publicly looking. Companies look for jobs that never get posted. So the recruiter can really, really help you in that way. But like I said, sometimes new hire companies that are hiring don't want to work with a recruiter because they don't want to pay the fees. So get your current one to pay the fees and stuff like that. That can be really, really valuable. It also just helps you not have to stress as much. All right. If you get 2 months of severance, let's enjoy that. 2 months, that's not 2 months that you need to freak out and panic. Enjoy your time off. Learn something new. Travel. And yet know that somebody's out there trying to get you a job. That right there, peace of mind for a few months, few weeks to breathe. That's really amazing, right? When was the last time you got a 2-month break? This type of stuff. So can it be valuable? Absolutely. Okay, one last one. Can I negotiate severance terms after I've signed? Usually no. Usually no, because you've already agreed to it. So why would they reopen negotiations? It's not in their favor. And that's the truth about any contract. A severance agreement is just a contract. It's a contract just like all the other contracts out there. Once you signed, you've accepted it. But you do not have to sign. So make sure that you're negotiating to get what you want, or walk away. Walk away if you want to. If you're like, no, I'm not going to sign an extended non-compete. I want a job. I have a job lined up. I'm not going to sign this. Those are your choices. 100% your choices. All right. Also, CEO Legal Coach here. Again, I've got a program called Severance Studio where I break down everything, give you checklists, walkthroughs, videos, resources. If you've been recently laid off, you're facing a severance agreement, everything's in there. And then I also have some articles written at ceolegalcoach.com/severance agreement. And that's agreement singular. All right, I go live every Tuesday, Thursday, and Friday. And all this week, it is all about severance agreements. So keep thinking of your questions, your ideas. Share this with anybody who's being laid off or might get laid off, is scared of this, is nervous about it, because we want this to be a positive thing. Letting go of a job that wasn't right for you can actually be an amazing, amazing, powerful thing for you in your life. Let's let it be that. Let's work to make it that so you have an amazing